Well, so what happened? How did we get runaway government, massive debt? Only $20 trillion now, right? Pocket change. And loss of liberty. The government seems like the government's in every aspect of our lives these days. So what happened? Okay, so just a brief review. Constitution protects individual rights with the presumption of liberty and with the enumerated rights in the other amendments. And it limits government power because government has only the enumerated powers in the Constitution, the federal government, that is. Just because your rights are not listed in the Constitution doesn't mean that you don't have those rights. And most of the cases I'm going to deal with now are from that era, the Great Depression, New Deal era. And that's when a lot of the damage to the Constitution was done. And the case is called O'Gorman versus Hartford Fire Insurance. And this had to do with the rates that insurance brokers could charge in New Jersey. And in New Jersey, the legislature passed a law that limited the amount of money that insurance brokers could get whenever they found insurance for somebody. And surprise, surprise, these amounts were less than they could get in the free market. And even bigger surprise, it was insurance companies that were pushing the legislation. So the insurance brokers were mad about this, and they said this was a violation of their due process rights. They were being deprived of property, and money is property, without a due process of law. And so this gets to the Supreme Court, and the Supreme Court basically takes a phrase that they had used a few times earlier and dusts it off and really dresses it up and starts making a big deal out of it, and it was called the Presumption of Constitutionality. Okay, well, that sounds fairly harmless, right? Presumption of constitutionality? Well, except what it really is doing is it's replacing the presumption of liberty. And the presumption of constitutionality is that if Congress or a state legislature passes a law, the Supreme Court is going to start with the presumption that it's constitutional. So you get this presumption of constitutionality, which replaces the presumption of liberty. So now, instead of presuming that the individual is right, we're going to presume that the government is right. And this shifts the burden from the government to prove that they have a compelling reason for doing what they're doing to the citizen who's being harmed by the government law to prove that it's unconstitutional. Let's talk about the General Welfare Clause. Now remember, Congress shall have power to lay and collect taxes to provide for the general welfare, but it's got to be tied to an enumerated right in the Constitution. Here's what Madison had to say about the General Welfare Clause. And of course, he's one of the people who was writing the Constitution. He said, "Money cannot be applied to the general welfare otherwise than by an application of it to some particular measure conducive to the general welfare. Whenever, therefore, money has been raised by the general authority, meaning the federal government, and is to be applied to a particular measure, a question arises whether the particular measure be within the enumerated authorities vested in Congress. If it be, the money requisite for it may be applied to it. If it be not, no such application can be made. If Congress can do whatever in their discretion can be done by money and will promote the general welfare, the government is no longer a limited one possessing enumerated powers, but an indefinite one subject to particular exceptions." This came up in 1937 in the case of Halvering versus Davis. And this was when Congress passed the Social Security Act. And some people were against the Social Security Act, and they came up with an argument, and they said, well, there's no enumerated power in the Constitution that would support Congress having a Social Security Act. And by golly, they were right. You'd think that was a pretty good argument, wouldn't you? Well, so the people who were in favor of Social Security said, well, wait a minute. This is for the general welfare. Well, yeah, it's for the general welfare, but what about an enumerated power? You still got to have an enumerated power, right? And then the Supreme Court decided, you know what? You don't have to have an enumerated power anymore. We're just going to separate those two things. General welfare, enumerated powers. If it's for the general welfare, we're not going to worry about whether there's an enumerated power. Now this, of course, suddenly makes the government tremendously more powerful. They can do a lot more things because all they have to do is say it's for the general welfare. Now, I think the general welfare, I think that clause was put in there really as a restriction on government power. Anything you do has to be for the general welfare. Anything you spend taxes on, unless it's for paying a debt or common defense, but it's got to be for the general welfare of the United States. And that it's not just for one state's benefit or the benefit of a few people or something like that. But it's still got to be tied to an enumerated power. That is, until 1937, when the Supreme Court decided that it didn't have to anymore. Commerce Clause, to regulate commerce among the several states, basically to keep trade free running. Now, if you take a law school course on constitutional law, there will be a section in that course where you go through a whole series of Commerce Clause cases, where you see how the Supreme Court, little by little by little, has just expanded what the Commerce Clause means, so that instead of just being there to make trade run regular among the several states, it gives Congress the power to regulate, and in the strong sense of regulate, almost any economic activity, and it can even be all within one state, because they'll just say, well, that'll affect people in other states somehow. And so it doesn't even have to be across state lines anymore. So I'm not going to go into all the Commerce Clause cases. I'm going to talk about a couple of them. In 1938, the United States versus Caroline Products. And the picture that you see is a can of what is called filled milk. And filled milk was regular milk that had the milk fat removed and replaced with some kind of vegetable oil, usually coconut oil. Well, why would somebody do this? Well, it turns out it's a little bit less expensive than regular milk. And, of course, this was the Great Depression. If you could save a few pennies on a can of milk, you might do that. And so a lot of people were buying this, and they were pretty happy with it. Some people were not so happy, namely the people who were selling other kinds of milk that were more expensive. So what did they do? Well, first they started a propaganda campaign against filled milk. Don't let your family fall victim to the evils of filled milk. And the mother is protecting her children and saying, stand back, children. It lacks essential vitamins and minerals. Okay. So, at least here, they're exercising their free speech rights. I don't know how true any of this was, but they're saying things to stop people from buying filled milk. Apparently that didn't work very well, because they went further, and they went to Congress, and they got Congress to pass a law banning the sale of filled milk in interstate commerce. The U.S. Supreme Court said that the commerce power reaches far and wide, and was kind of vague about it. So they said that Congress could do this. Now, I want to make a comment about this. A lot of people complain these days about how much money there is in politics. And they make a lot of laws about how much money you can give to politicians and so forth. But one of the reasons there's so much money in politics is because of cases like this, Caroline Products. Because what is the lesson from Caroline Products if you're in business? Is it you make a product that people want and sell it at a better price? No. That's what Caroline Products did, and they went out of business. The lesson from this is if you want to be successful in business, you go to your congressman, you give them lots of money, you get them to pass legislation that will help your business and hurt your competitors. So that is what is going on a lot of the time. Now, since Congress can start to mess around with the economy, they've got something to sell to people in business, and people are willing to go there. And of course, they're giving donations for altruistic reasons, because they want to have a better country and everything, not because they're trying to hurt their competitors or anything like that, of course. But if you're worried about too much money in politics, this is one of the reasons that we have this. I'm going to give you another Commerce Clause case, and this is 1942, Wickard versus Filburn. And this is about the Agricultural Adjustment Act. And that was an act passed by Congress in which Congress said that they could tell you how much of a certain crop you could grow on your own farm. And it certainly didn't help this guy, Roscoe Filburn, who filed this lawsuit. He had a small farm, and he grew not too much wheat on his farm. And even the Commissioner of Agriculture admitted that the wheat was all consumed on the farm, either by Roscoe and his family or their animals. And he sold the animals, he didn't sell the wheat. And of course, the wheat didn't go out of state, it wasn't sold at all, it didn't go across state lines. And he thought that it was not fair that Congress could tell him how much wheat he could grow on his own property. Well, the Supreme Court allowed Congress to restrict the growing of wheat under the Commerce Clause. First of all, they said it's not just that Congress has a right to regulate commerce. Congress has a right to regulate anything that substantially affects commerce. Well, wait a minute. That's not what it says in the Constitution. That's already expanding the meaning of the Commerce Clause in the Constitution. But even then, you might ask, well, wait a minute. He wasn't growing that much wheat on his farm. This had a substantial effect on commerce. This wheat, this guy was growing on this one little farm. And the Supreme Court said, well, wait a minute. There's something called the Aggregation Principle, which they knew about because they had just made it up. The Aggregation Principle says it's not just Roscoe Filburn on his one little farm with this small amount of wheat. It's all the little Roscoe Filburns all over the country, all the little guys on their little farms. If you let them grow as much wheat as they want, that's going to substantially affect commerce. And therefore, Congress has the right to regulate this. And Congress and the Supreme Court just love this case. And you will see it cited again and again and again. It's been cited hundreds of times in Supreme Court decisions, because this is basically the case that shows that Congress can do almost anything it wants with the Commerce Clause. And they'll say, well, hey, whatever you're complaining about, that's not going as far as they went in Wickard versus Filburn, so obviously Congress can do that. Unfortunately, the Supreme Court pays a lot more attention to its own precedents than it pays to the Constitution.